Hi, my name is Jiyae Hwang. I am a senior associate at Scott Legal PC, and today we're going to spend some time talking about the visa options available for individuals with extraordinary ability in their fields. So just a few things before we get started. Scott Legal is a full-service immigration law firm, which means we have expertise handling a wide variety of non-immigrant and immigrant visa categories suited for various circumstances. So whatever your immigration needs may be it a family-based, employment-based, or investment-based immigration matter, we can help you find a solution. We will be continuing this webinar series, and we are doing at least 2 webinars a week on different immigration law related topics. And at the end of this webinar, we will be sending out a few things for the benefit of all participants. So first, we will send you a copy of the PowerPoint that will be used in this webinar today. We will also send you a visa guide, which is a comprehensive guide to the visa types that we will introduce in this presentation. We will also send you a link that you can follow where you can sign up for additional webinars that are coming up in the future, and also a link to this webinar as it will be recorded. This webinar will also be made available on YouTube, and we do encourage you to subscribe and hit the notification button to our channel as we regularly upload a variety of immigration-related videos that can be helpful to you. Finally, we will send you a link that you can follow to set up a consultation with one of us, our experienced attorneys, should you wish to discuss your case in further detail with us. So today, we're very lucky to have Kelly Weiner, who is a partner of the firm, with a wealth of experience handling cases in all of the visa categories we will be speaking about today, who will be presenting about the various options available to extraordinary ability individuals and the requirements and considerations. Finally, for any questions you may have, please feel free to add them to the chat box or use the Q&A function, and we will try and get to all questions. So without further delay, let's get started.
Thank you, Jiyae. All right, so let's go to the first slide and talk about just what are the extraordinary ability categories. And the ones listed here are the O-1A and the O-1B, which are both temporary visas. So that means that if you have kind of work in the United States and you want to come temporarily and fulfill that work, these are what these visas are for. We will also talk about green card options in this presentation, and green card options are for people who want to live and work in the United States permanently. So for the O-1A, this is a temporary non-immigrant visa for individuals with extraordinary ability in the sciences, education, business, or athletics. And it has a very high standard, which is you have to be one of the small percentage who's risen to the very top of your field. We're going to contrast that with the O-1B, which is separated out. This is another temporary non-immigrant visa for people with extraordinary ability, but particularly in the arts. And then there's a separate category for people with extraordinary ability in the motion picture or television industry. And these are treated a little bit differently. So the standard for the arts is slightly lower than the O-1A. The person must have received distinction, meaning a high level of achievement, evidenced by a degree of skill and recognition substantially above that ordinarily encountered. And then the standard for the motion picture and television industry is a bit higher. You have to show that you have that extraordinary ability in and a record of extraordinary achievement in the motion picture or television industry. So it's in relation to kind of your peers within the industry, showing that you have that, that extraordinary ability. All right, so let's talk a little bit about the green card options for people of extraordinary ability. So one is the EB-1A. This is, very similar. The requirements kind of will mimic what the O-1A and the O-1B look like. But there is no kind of separate category for the arts and then for education, sciences, business, and athletics. It's all under kind of one umbrella of the EB-1A. And the standard is the higher standard of someone who has risen to the very top of their field and can show sustained national or international acclaim in their field of expertise. Importantly, also the person must be coming to the United States to continue to work in that area of extraordinary ability. So if somebody's had kind of a very illustrious career, but they want to just retire, that's not going to work for the EB-1A. They will want to see kind of a statement of proposed intent and what you plan to do in the United States, and it does need to be related to your area of extraordinary ability. Um, let's also talk for a minute about the kind of EB-2 national interest waiver green card. This one is not always lumped in directly with extraordinary ability visas, but is a very good option for people who maybe were on an O-1, or maybe an O-1B, and maybe don't quite meet the EB-1A standard yet, but still have a very impressive background and are working on an endeavor in the United States that has substantial merit and national importance. So the EB-1A and the EB-2 national interest waiver, one very important thing about both of these categories is that you can self-petition. You do not need to have a U.S. employer, which is not the case for many other green card categories and is not the case for the O-1A or O-1B. For those temporary visas, you will need either a U.S. employer, a U.S. agent, an agent operating for a foreign employer, but there's more flexibility with these kind of green card categories. For the EB-2, you do have to meet a threshold requirement of an advanced degree or exceptional ability in your field. And it's really going to be important. What is your proposed endeavor? Does it have this substantial merit? Does it have national importance to the United States? And Jiyae will talk about this later in the presentation. Particularly national importance is something that's coming up a lot right now, and that adjudicators are really focusing on. You also have to show that you as the individual are well positioned to advance this particular endeavor. So there needs to be kind of a nexus between your expertise, your experience, and what you're working on. And then based on that, you will argue that it is beneficial to the United States to waive the normal labor certification process that requires a U.S. employer, that requires a labor market test, and that you should not have to go through that because what you're working on is so important that it's beneficial to have you in the US, or there's other factors you can argue. For example, entrepreneurs can argue that the labor certification process is not set up for them. And we'll get more into detail on the EB-1 and EB-2 later in the presentation. All right, so let's look at the O-1A visa requirements and what you need to demonstrate. So you need to show that you either have a major internationally recognized award like a Nobel Prize or a Pulitzer Prize, or much more commonly, people are going to qualify on the basis of showing they meet at least 3 out of the following criteria. So 3 is the minimum. But you would want to have more if at all possible. The listed here, kind of receipt of nationally or internationally recognized prizes or awards. And you want to think about, were these awards that you won as a student? Was it something given by your university or college? If so, that's not going to be very compelling. For these types of petitions, you don't want to just include every single thing you've ever done. You do want to think strategically about, when I submit this, holistically, when the officer looks at my application, will they feel that I'm someone of extraordinary ability who's risen to the very top of my field? So including things like student awards that were won at university can actually start to lower your profile in their eyes, and they will likely just discard it. However, in contrast, if you were in university and you won a very prestigious award where other professionals in the field also competed, you could and would want to include that, as well as kind of proof of the criteria, who else competed, and show that it wasn't just a university, award. So another would be membership in associations in your field, which require outstanding achievements. So again, any lawyer, for example, who has passed the bar can join a bar association by paying a fee. That's not a good membership for kind of the O-1A. What you would want is a membership that actually requires you to have some outstanding achievement in order to be invited or in order to apply to become a member of that association. So it is important to look at, what are the requirements for entry? Can anybody at any part of the profession enter, or does it actually require these outstanding achievements? So publish material in professional or major trade publications or major media about you and your work. So similar to the other criteria I've talked about, again, you don't want to just include every single thing that's ever happened, to you. Like if your school paper did a profile on you, that is not going to be that compelling. But if, the Wall Street Journal did an article about you or about your work or something you were working on, that might be something you would want to include. So others, I'll kind of run through more quickly, original contributions of major significance. This you're generally going to demonstrate, if you have patents, if there is, media about this, and then also through kind of expert letters, which are written by people who are themselves experts in the field, some of whom may know you from working with you, some of whom may not know you personally, but know of you through your work. And those are also very important when they can speak to your extraordinary ability because they are aware of you as somebody extremely important in the field. Authorship of scholarly articles in professional journals or major media also can be important depending on your area of extraordinary ability. We often work with entrepreneurs, or people who are, applying on some more niche field who might ask, well, I don't have publications. Is that just a bar to applying? And the answer is no. Yeah, this is just one criteria out of several. As long as you meet three, or more, you can still qualify. And publications are not a requirement, especially if you are qualifying as an entrepreneur or someone kind of outside traditional academia. Um, a high salary or, as evidenced by contracts or other reliable evidence. Again, here you're going to be looking at what is your area of extraordinary ability, where are you working, and are you earning a high salary in relation to others in the field in that area. Participation on a panel as a judge of a work of others. Also important to think creatively about this one. So for example, if you're judging competitions, if you're judging, if you're doing peer review for articles, or for publications, that can be something that could be included. And then employment in a critical or essential capacity. But again, for organizations with a distinguished reputation. So you do have to kind of meet each of the criteria within, the requirement. And so maybe you were CEO of a very, very small company. If you cannot show that company had, a distinguished reputation, that may not be a strong criteria for you. All right, let's look at the O-1B. And so as expected, these are much more focused on the arts, what would be relevant for the arts. It has a similar structure to the O-1A in the sense that you're going to qualify either by one significant national or international award or through three of the following criteria, which are broken up on the next two slides. I won't go over each of these in detail, but it's a similar idea, to the O-1A criteria in the sense that, again, you don't want to include, things about your, if you were the star of your high school play, that's not going to be useful. You really want to think about what in your portfolio will elevate you and show that you are someone who has achieved distinction in your field. In this one, you may also need to be a bit more creative as some of the criteria are a bit dated. For example, talking about things like evidence of, major commercially or critically acclaimed successes in the performing arts is shown by box office receipts or, record, cassette, compact disc, or video sales. So some of these are a bit, again, a bit dated. When they were written was quite a long time ago, and there's been changes in the field. And there is, this last category of other comparable evidence. So that's to say, if you're applying, for an O-1B in kind of a very odd or niche field or something that is not going to have some of these markers of more traditional arts achievement, you can try to argue this comparable evidence category, but you do need to show that in your field, the other criteria are not relevant. So it is kind of a big hurdle to meet, but something that you could consider, especially if you have a field that is just very non-traditional, but you are arguing that it is an arts field. All right, so let's go over some of the important differences and similarities between the O-1A and the O-1B. So the O-1A, again, is for sciences, education, business, or athletics. The O-1B is for arts or motion picture or television industry, and those are kind of two separate subcategories. The standard for O-1A is quite high, small percentage who's risen to the very top of their field. Arts a bit lower with this distinction, high level of achievement. That's to say that if you are in a field where there is maybe some argument that it could be an O-1A or it could be an O-1B, kind of people like mixologists come to mind. There are, certain categories where it's a bit more flexible. If you can make a strong argument for an O-1B, that may be a better route to go, just because, the standard of distinction is a bit easier to meet. And again, for motion picture and television industry, this is, extraordinary ability in relation to, other within the motion picture and television industry. In terms of how long they're issued, visas can be issued for 3 years, and then they can be extended for 1 year if you're finishing out the same, set of projects. If you can make an argument that there's either new employment or you have a new set of projects that you're being hired for, then you can potentially get 3 years. So that's something that over the years, USCIS has changed how they adjudicate it. But for several years now, if you can make that argument for new employment or a new set of projects, you're able to get kind of that 3-year extension. Your family also can come to the US with you. That includes your spouse and any unmarried children under 21. They can attend school while in the United States. Unfortunately, the spouse does not gain work authorization. So if your spouse does need to work in the US, they would need to look at some other visa category to allow them to work. All right, let's go over the EB-1A. So this is, you'll see here, kind of very similar to, the O-1A and the O-1B, but, some of the language is a bit different because it incorporates both arts and sciences, education, business, and athletics. We have not listed it here, but it is a similar structure where if you have won one major award, you can try to argue that you qualify on the basis of that one major award. But most people will be qualifying based on showing they meet at least 3 of the following criteria listed here. And very again, very important that you show that you meet the criteria by strategically including evidence that is not going to make your profile look weaker. So we're going to talk about this a bit more on the next slide, but the way that they adjudicate extraordinary ability cases is 2 steps. So I think we can go to that slide so we can see that information. So there's really 2 steps to how they adjudicate EB-1A, O-1A, O-1B. And this is one to look at, have you met the criteria, like of the regulatory language? Have you included proof of awards, proof of memberships, proof of, employment and critical essential capacity? Okay, so if they have evidence for each of those things, they can proceed to that next step. We have, evidence for at least 3 of the following criteria. In that second step, though, they are going to consider the quality of the evidence and consider everything in totality to make a final merits determination on whether you are one of the small percentage who've risen to the very top of your field of expertise. That's why I've continued to mention being strategic in what evidence you include, because if you just throw every single thing at them, you may meet that first step. But in that second step, by looking at some of the more junior work, or if they feel, well, you were just padding the application because you didn't really have much to offer, that is really going to hurt you in step 2. And so what you want to do is when you're thinking about putting together these applications is think strategically about what to include and think about leaving the officer with the impression of, wow, this person really has extraordinary ability. The people that have written them these letters are very high up in the field. The awards that they've won are very prestigious. So if you have very, very strong evidence for 4 categories, and then you have, a really weak membership, maybe you don't include that membership. So that's a very important discussion to have with your attorney, because I think there are times where you may want to include it, you may want, not want to include it, but it is something that will help your case if you look at it holistically as opposed to just, I've met each of these criteria separately. Again, you want to think about how is the officer viewing the entire application during this final merits determination.
All right, thank you so much, Kelly. So now let's shift gears a little bit and look at the EB-2 National Interest Waiver green card option. So as Kelly mentioned in the earlier slides, the EB-2 NIW is another pathway for a green card that may be accessible to individuals who have extraordinary ability in their fields. There is considerable overlap in some of the arguments that can be made, and also has the advantage of, allowing self-petitioning which means you don't need to have a U.S. company to sponsor the green card application. You don't need the U.S. sponsor company to go through the labor certification process to prove that there is someone else in the United States. There is no one else in the United States who can take your job. So the EB-2 NIW can be a very attractive option to certain individuals who meet the criteria. So let's go through the eligibility requirements of the EB-2 NIW green card pathway. So the first thing to note is the EB-2 threshold requirement. And this requirement is applicable to all EB-2 green card applicants under that category, with or without the NIW request. Basically, to meet the threshold requirement, you have to prove either one of the two things. The first pathway is by showing that you have an advanced degree in your field, which is defined as a master's degree or higher. So it'll include, degrees like a PhD degree, even degrees like a JD degree or a MD degree, for example, which require a bachelor's degree to, in order for someone to gain admission to that kind of program, you can use those types of degrees as a master level degree, advanced degree level. And if you don't have a master's degree or higher, another pathway you can be considered a advanced degree holder is if you have a bachelor's degree in your field, but also 5 or more years of post baccalaureate progressive work experience in your specialty that is related to the degree. And if you have that, the combination of this bachelor's degree and 5 or more years of progressive work experience can qualify you as basically the equivalent of an advanced degree holder in that field. Now, one thing to note is that the word progressive is quite important here. So when you are trying to qualify under, the bachelor's plus 5 years, then you need to have the evidence that not only did you work for the 5 years after you received your bachelor's, but that your duties at the job and the responsibilities that were given to you changed over time to encompass more senior duties, to encompass more complex duties, such that we can show that progression. And this can be shown by things like changing titles. This can be shown by, really changes in the job duties. And it is very important to get a official employment confirmation letter from your previous employer that outlines this change with the requisite detail needed. And it is important to, get that official letter from the employer along with the proof of your degree and proof of U.S. degree equivalency report if your degree is a foreign degree. So if your degree is not from a U.S. institution, for each case, no matter if you're using a master's or if you're using a bachelor's, you do need to also provide the U.S. education equivalency report from an evaluator in the United States that will confirm that the degree that you have from your foreign country is indeed equivalent to the same level that is required per the regulations. Now, if you're not trying to qualify with a degree per se, then another way to qualify for the EB-2 threshold is by showing that you have exceptional ability in the sciences, arts, or business. And it is important to note that when we speak of exceptional ability, it is a much lower standard than the extraordinary ability standard that we have been discussing in the O-1 and EB-1 context. So holistically, the evidence must show that an individual has a degree of expertise that is significantly above what is ordinarily encountered in the field. And significantly above what is ordinarily encountered is definitely lower, is a lower standard to meet than having to prove that you're one of the small percentage who have risen to the very, very top of your field. So how do you prove that you have this exceptional ability, a degree of expertise that is significantly above what is ordinarily encountered? So you must be able to show at least 3 out of the enumerated types of evidence here. And this includes things like, any degree that is relevant to your work, 10 years of full-time work experience in your field. And this would also need to be substantiated by detailed letters that confirm that you have working in that profession from previous employers. If you have evidence of having commanded a high salary that is significantly different in relation to others, you can also add that. Recognition for your achievements and significant contributions to your industry or field by your peers, government entities, professional or business organizations. So this can include letters of support from such organization that discuss how your achievements have, changed the field in a better way. So there are a variety of evidences you can rely on, but you do need to at least be able to provide three out of these examples in order to make the case that you have exceptional ability. And if you're going to that route, you do not need to show a master's degree or the equivalent of a master's degree. Now that the threshold requirement has been met, the other challenge with regards to being eligible for a green card through the EB-2 NIW category is to demonstrate that your case qualifies for a national interest waiver. And when we speak of waivers, it means that you're asking the government to exempt you from the ordinary requirement for you to have a job offer from the US, to have a US company that is willing to sponsor you, and to have that US company go through the labor certification process, which is ordinarily required to test the labor market to see if there is any other US professional who can take your job. But if you can prove that your case qualifies for the NIW, you are exempt from that, process. You're exempt from that onerous requirement, and you can actually self-petition for your green card as well. So it is very important to make sure that you have a strong case, that your case merits an NIW. So there are three prongs of basically the test of whether a case merits an NIW, and that is promulgated by a case called Matter of Danizar from 2016. And the first prong is that the applicant must be able to prove that their proposed endeavor has both substantial merit and national importance. The second requirement is that the applicant must show that they are well positioned to advance the proposed endeavor. And the third requirement is that there must be a showing on balance that it will be beneficial to the United States to waive the requirements of a job offer and thus of a labor certification. So let's unpack that a little bit and talk about what that really means. So proving that the proposed endeavor has both substantial merit and national importance. So the proposed endeavor is basically what the applicant plans to do in the United States. It is kind of the applicant's future plan. And it is more than just proposing that the applicant will work in a field. So, for example, if an NIW applicant says, okay, I'm an engineer and I will continue working in the United States as an engineer, that sentence on its own will not be specific enough to, constitute a proposed endeavor. By contrast, a proposed endeavor is more specific about what the applicant will do in that occupation. So for example, if an engineer is coming in and say, I'm an engineer and I am going to help this company X work on this R&D project. They're developing a new design of a semiconductor chip that allows more data to be stored in, the same amount of space or something like that. That is more specific, and that is closer to what the government will expect to see when the applicant submits a proposed endeavor. Now, such a proposed endeavor must have both substantial merit and national importance. And let's talk about what that means. Substantial merit and national importance can be proven in a wide variety of fields, including health, business, education, science, and technology. And endeavors that tends to further human knowledge in such key areas such as medical advances or, things that improve civil engineering practices, those types of endeavors that, advance human knowledge are likely to qualify to have substantial merit and national importance. Really, the question to ask is, what is the prospective impact of what I'm trying to do? And, how can this benefit, the country and society and the industry in a broad way? So an easy way to think about it is the government is looking at an endeavor and asking themselves, will this particular endeavor only benefit the immediate employer or the immediate clients that are using the applicant's services or the applicant's, product? Or Or will this endeavor result in advancing the field in some way, changing, best practices in a particular area, like medical advances, right? If you, develop a new drug that will increase the efficacy of some type of, disease prevention, then not only is it going to help the company that is developing the drug, but it is changing medical practice and, improving public health. And there are a lot of broader benefits that we can talk about that is resulting from the endeavor. So it is very important to think about what the specific plan is that the applicant is proposing, and then think about what is the expected impact from that particular work, and can we have an argument? Can we present an argument that the benefits will be broader than just, the immediate employer who uses the person's services or the immediate clients who are using the products of, that particular invention. Um, other things that can help is, for example, if you are publishing research or publishing a patent with a new invention, for example, and if that patent has the potential to be licensed to other, companies in the field, such that that kind of knowledge dissemination can also count as a broader impact to the field, because not only are you, helping, your own company, but you're also, publishing intellectual property that can be used by others as well and can be, benchmarked by other inventors who are working on similar endeavors. So there are many different evidences you can collect to try to meet the national importance criterion, and those include things like expert letters, letters from people in the industry who can describe, the prospective impact of what you are planning to do in your particular field. Government pronouncements and declarations can be helpful if there are other evidence in the record that, makes the link between how your particular project will make a significant impact on a field that is important to the government. So even if the government says that some area is important for the nation, that in itself would not likely be enough to show national importance. You do need to bring it back to your specific proposed endeavor and describe how your project will make a significant impact to advancing those priorities. Other data showing importance. Really, you can be creative about, what kind of documents that you can provide to substantiate the future prospective impact. Really, the strategy depends on the specific facts of each case. For entrepreneurs, for example, maybe you have a really groundbreaking startup idea and you have been approached by prestigious incubators or accelerators who want to, incubate that project. That kind of industry validation can also serve as an indicator of a broad prospective impact of what you're doing. So really, there is no one way to, prepare a file to successfully argue national importance. It really is a case-by-case endeavor. Now, let's talk about the second prong, that the applicant is well positioned to advance the endeavor. And really here, the inquiry is about the person themselves, the person who is applying for the NIW. Are you educated and experienced enough to bring forward this, the plan in the United States that has substantial merit and national importance? Do you have a track record of success in similar projects that were also successful, which will give an indication that your current project will also be as successful? Have you published any intellectual property in the past, such as patents or journal articles if you are a researcher in your field? So that kind of track record of previous successes can really help meet the second criteria, that a person is well positioned to advance the proposed endeavor. And it is in that area, maybe there can be a significant overlap with extraordinary ability applicants who may already have that record of success. So you can use those types of evidence of recognition in your field to your favor when you're arguing that you're well positioned to advance the proposed endeavor. Finally, the third criteria is that there must be a showing that on balance, it must be beneficial to the United States to waive the requirements of a job offer and thus of a labor certification, because there are policy benefits of having that requirement that, a company must be able to, prove that there is no other U.S. worker who is minimally qualified for the job before inviting a foreign worker to take that job. The usual benefit is protecting the U.S. labor supply. But there may be countervailing benefits of a person's very specific proposed endeavor that outweighs the ordinary benefits of, the policy benefits of protecting this one labor position for, this job. For example, if your work will, broadly enhance societal welfare, or for example, if your work will broadly advance a key area of technological advancement that the U.S. thinks is very important and which will create even more jobs by, making the U.S. industry more competitive. So those types of arguments can work very well. If you are an entrepreneur, for example, and if your business project will create a high number of jobs in the United States, that is definitely a countervailing benefit to, the labor certification programs, policies, which, intends to protect the supply of jobs in the United States. So there are many different arguments that you can make. Usually, some of the arguments that you've already made in prong one, describing the systemic and broad benefits, can also be used in prong three. If you can show that you have very unique record of success and very specific know-how that can't really easily be replicated or replaced by someone with minimum credentials in the United States, that can also, from those data from the second prong can also be used to support the third prong by showing that the labor certification process will not really adequately, be enough to replicate that kind of benefit that you would be able to bring because of your unique skills. So there are different strategies that you can use. All right. So now let's shift gears a little bit and talk about some of the documentary elements of an extraordinary ability visa petition. And expert opinion letters is a good topic to cover because expert opinion letters are relevant in all types of visa applications that we talked about today, including the EB-1, O-1, and the NIW. So what is included in expert opinion letters? So for these types of extraordinary ability petitions, it may be good, and it is really a key part of such petition to obtain expert letters from key individuals in the industry. And this can be past employers, this can be colleagues in your field, this can be former clients, professors in the field who have a lot of academic knowledge in your particular niche, and famous people who already are known as leaders in the industry, such as Nobel Prize winners. That's one example. But generally, the more authoritative the person's voice is in the industry, the better the strength of the expert letter will be, because USCIS will, put more credibility on an expert who obviously appears to have the right type of insight into the field. So who is writing the letter? Usually what we would do is with the letter that we submit from the expert, we would also include background information about the person who is writing the letter. And with the letter, we would normally also include a full-length CV, resume of the person who is writing the letter that outlines, where they have worked, what are the awards and other types of recognitions that they have achieved in the field that will boost the credibility of that letter. Now, when we talk about choosing the experts to write the letter, really the people who are writing the letter depends on the purpose the letter is going to serve, and also what type of arguments you're trying to bolster in that petition. So if your petition has maybe particular weaknesses that you want to address, so maybe you have strong evidence of well-positioned, but maybe you want to bolster the national importance argument, maybe then you would want to get a letter from a government affiliated person. So those types of strategic considerations will be important when you are selecting experts. Now, let's say if you want a letter to support an EB-1 or O-1 petition, you want to get a mix of letters from people who know you directly, with regards to, having worked together, for example, and people who are called independent experts. So independent experts are people who have not worked with you directly, but nevertheless they know you through your reputation in the industry. And to really provide a strong claim that you are someone who has that international or national acclaim, it will be important to have both, because the USCIS may think that letters from an independent expert, it tends to be more objective when they talk about things like standing in the field. So inner circle letters, people from people who know you and have worked with you before, and independent letters have different functions, and they may have different, you know, benefits to a file. So for example, if you're preparing an O-1 or EB-1 case, and if you're trying to prove that you've played a leading role, a critical role in a distinguished organization, it will be important to get a letter from an expert who is involved with that particular organization to prove that you have played this critical role, and also provide detailed and concrete explanation about what exactly did you do for this organization, and what were your personal contributions to that organization. Why can this be, described as a significant contribution to the field and to the organization? So those types of very detailed testimonials can be persuasively elicited from such experts who have worked with you before in such organizations that you've been involved in. Now, by contrast, independent experts may, be in a better position to talk about your general standing in the field and the industry-wide recognition that you have enjoyed by your contributions. So the content of such expert letters will need to be very detailed. USCIS does not like to rely on what is called conclusory statements, which is basically just repeating, the regulatory standards. So simply stating that someone made a contribution to the field will not in itself be enough. We will need to provide concrete detail about exactly what the person did, what was the challenge in the industry, how did the person solve the challenge for the industry, and why does this, really set the person apart from the prevailing approach or the prevailing, level of expertise that you see in the industry. And concrete details, specificities really help bring those details forward, and make the profile more authentic and persuasive in the eyes of the examiner. So it is very important to make sure that the expert letters have that detail. Really, the length of the expert letters is not that important, but really is more about the content. Does the expert letter focus on the right things? And is the expert letter providing the right type of detail that is relevant to the regulatory criteria? So it is important to work with, a legal team that understands the nuances of what can be effective in terms of making a persuasive petition when you're preparing a petition like that. All right, so now then, let's talk about some other strategic considerations that may come up if you are trying to choose which, visa category you are planning to apply for. So the first question to ask is, do you want to stay in the United States temporarily or permanently? So as Kelly mentioned before in the previous slides, the O-1 visas are non-immigrant visas, and they are well suited for, if your plans in the United States are temporary. If you maintain a strong connection with your home country, and if you need to travel back and forth, and maybe you want to have the freedom to stay, abroad for long periods of time, the O-1 visa could be a great option for you, and well suited for that purpose. By contrast, the EB-1A and NIW are both green card categories, and best suited for people who plan to live in the United States permanently. There are responsibilities to when you're trying to maintain your permanent resident status, including how long you can travel outside the United States at a given time. So this would definitely depend on your future plans and where you want your primary residence and your professional arena to be. Now, the green card will also one day can open up the way to U.S. citizenship. So if that's the kind of trajectory that you're looking at, the EB-1A and NIW would be great choices for that. Do you have a U.S. employer or agent, or do you want to self-petition? That is also another very important question. The O-1 visa categories does require a U.S. petitioner. That means that can mean either a U.S. employer or a U.S. agent who serves as, the entity that is driving forward the petition, and you are the beneficiary who will receive the visa. So if you have no connection to the United States at all, an O-1 may be difficult. However, one thing to note is that we have worked with entrepreneurs before who actually set up a new US business entity in the United States. And that startup, that US legal entity, has been able to serve as the petitioner to drive forward the O-1 visa. So that is one strategy that you can consider. Um, Now, if you're using that strategy, you do need to show something more than just having an entity in the United States. So, for example, deal memos, letters of intent, contracts with third parties that show that there is actually work in the United States that is lined up for this new entity. That kind of evidence would be important to add more color to that work arrangement. But definitely, it is an option for entrepreneurs to take if they want to set up their U.S. entity, and that entity can serve as the petitioner. By contrast, the EB-1A and NIW are green card options that allow self-petitioning, which means the foreign national themselves can be, the petitioner and the person who will be driving forward the petition. So you don't need, a U.S. connection to make that application. However, it may be beneficial, right, to have some sort of connection to the United States. When you're talking about your intent, if in the EB-1A context, you'll propose that you will continue working in the United States in that field, and a letter of intent or a partnership from someone could be helpful to that regard to support that. In the EB to NIW context, when we're talking about the prospective impact to the field in the United States, having letters of intent from relevant entities and companies in the United States expressing interest can be very helpful in meeting some of the prongs. So that may still be relevant. However, formally, the foreign national can definitely, drive forward the petition on their own. Family considerations is another question to ask yourself when you're making this choice. For the O-1 visa category, your spouse and children under 21 can come with you to the United States as O-3 dependents. However, there is no work authorization available for O-3 dependents. So that means your, spouse and children can come with you, but they cannot be working. It is possible to go to school in the United States if that is what they prefer. For the EB-1A and NIW petitions, those are both green card categories, which means that your spouse and children under 21 can also apply for green cards as dependents and can also be eligible for the same benefits of things like work authorization and travel authorization if you are pursuing the I-485 option to adjust status in the United States. Each applicant for adjustment of status can apply to receive those benefits. All right, so now let's talk about some other types of considerations with regards to strategy when you are moving from a non-immigrant visa to a green card. The first thing to note is the differences in the qualification standard. So even though the regulatory language is written in a very similar way, practically, when USCIS looks at EB-1A petitions, they look at it with a much more stringent eye than they would when they're adjudicating an O-1A petition. And for an O-1B petition, that would be an even greater jump from an O-1B to an EB-1A, because, the regulatory definition of extraordinary ability is different in those contexts. So the important thing to note is that just the fact that you qualified for an O-1A or O-1B does not mean you automatically qualify for an EB-1A. It will be very important to see if there are any areas in your profile that you can strengthen before working on an EB-1A petition. If your O-1 case was maybe borderline or not the strongest in particular areas, it may help to come into the United States on an O-1 first, and then, use a couple of years to really strengthen your profile and collect stronger evidences supporting extraordinary ability, and then try for an EB-1A when you're ready. But if you, qualify for the O-1, and if your universe of evidence is already sufficient and very strong, then maybe you can, apply for the EB-1A as well. The way and the strategy will really depend on your particular circumstances. So it will be good to have a lawyer take a look at your profile and advise you of the realistic, strategy. Timing is another question to ask. Consider how much time is left on your current underlying visa, because some visas may be harder to extend or can be subject to more scrutiny once you have made some steps towards acquiring a green card, such as filing an I-140, right? So some types of visas are not affected by this consideration, this requirement for non-immigrant intent. The H-1B visa, for example, and the L visa are dual intent visas. And the O-1 visa, to a certain extent, is considered a quasi-dual intent visa. So it's less affected by that. But for certain types of visas, like the F1 visa or the TN visa, non-immigrant intent is judged pretty strictly. So if you are thinking of filing an I-140, in those kinds of circumstances, it may be a better strategy to, renew or extend your underlying visa first and then consider filing. Really, the timing of things can be very important. Make sure to discuss with an attorney to make sure you understand the risks and considerations involving that. Finally, family considerations can also come into the picture. If you have children who may also need the green card, consider filing for the immigrant petition early to avoid issues with the child aging out at 21 at which point they will no longer be eligible to get the green card. Right, so the final topic we will go over before going to the Q&A is that are extraordinary ability categories available for entrepreneurs? And the answer to that is yes. One thing to note is that EB-1A and NIW both are categories, green card categories that allow for self-petition, meaning both options are possible for entrepreneurs who may not have a third-party U.S. company to give them a job offer. The second thing to note is that changes in the EB to NIW standard made under the matter of Janissar, which is the prevailing case law for that category, did make NIW a much more accessible category for entrepreneurs. Now, there are huge caveats to that, and I would say the biggest challenge is meeting the national importance prong, because if an entrepreneurial project just tends to generate profit for the entrepreneur and for the entrepreneur's immediate clients, that can be difficult if you're not, if you cannot prove that you're making more of a broader impact to the field or, to the economy in general. There is another way that you could potentially qualify if you're generating a very, very high number of jobs that is proportionally significant to the working population of a region. If you are planning a large-scale project like that, you could, argue a national importance based on very large-scale, substantial economic benefit to a particular region or a particular locality. It is possible to apply for an O-1 visa as an entrepreneur if you meet, the eligibility criteria for extraordinary ability, which we went over in previous slides. However, there must be a separate U.S. entity that can serve as the petitioner. It is okay if you have ownership interest in that U.S. entity, but there must be that entity that is, legally registered in the United States to drive forward the petition. All right, so now let's see if there are any questions for us in the last few minutes. I don't see any that have come up. So yeah, I hope this presentation was helpful for everyone. Thank you for joining us today. And Kelly, thank you for sharing your expertise.
Thank you. Have a great day.
Have a great day.